All right, it's 10 and we're late. Good morning. You have two online. Okay, let me finish. I heard some. Good morning, Nathaniel.
Good morning.
How are you?
I'm doing awesome.
Great. Did you collect your book?
No, I just recently signed up, so I have to go in to go get my book.
Okay, all right, not a problem. Not a problem. So how we'll begin, so I can have an idea how to start. I can take with me. In class, we have with us Lovette Bethel. And online, we have Alicia Wilson and Nathaniel Alliday.
Higgs. Just
Let's put Higgs. Oh, well, I didn't put Higgs on the end, so I didn't put the first words that came up. Okay. So let's start with you then, Nathaniel, since you're the male in the class. Tell us about your trust experience.
I actually have not. I've just opened up a management and consulting company, and I want to open up a trust department. And so before I hire a trust professional, I want to be more familiarized myself.
Okay, now when you say open a trust department, what do you mean?
Because my management consulting company is actually a venture capital, a VC company. And so what I want to do is my clients, when I bring them in, I want to actually have them open up a Bahamian trust in the Bahamas so that we can manage it.
Okay, so my question to you is, does that require a license?
Well, it will. And so my lawyers is working that part out.
Yeah, because if you're going to be doing trust business, means you'll be acting as a trustee.
Yes.
And you know that require you having trust experience.
Yes, that's like I said, that's where the lawyers them come in. But I don't want to just turn over my trust department to somebody and I don't have no knowledge of what's going on.
So you've never done trust before?
No, I've never done trust before. I've just been dealing with wealthy people. I realize that is one of the financial vehicles that they use to secure their wealth, and so I just tap into it.
Okay, so I won't dampen your entrepreneurial venture project.
Yes, thank you very much.
Trust is it's a complicated creature.
Yes, I've sort of noticed.
And you do require a license to do trust business.
Yes.
Which means that you're going to be regulated. And that means you're going to have the required staff with the expertise that they're looking for. You're also going to have insurance. And then there are a lot of rules. There are a lot of filings to be done.
Yes.
So it's a journey for you.
Yes, it is.
Because you're gonna have to hire people with trust experience in order to get that off the ground, or even for the regulators to entertain it.
Yes, ma'am.
And trust personnel are not cheap.
Yes.
Yeah, it's kind of steep. All right, so welcome. So let's go to Alicia. Alicia, what's your trust background? Alicia.
Can you hear me?
I can hear you, but there's a lot of. Go ahead, try again. You put it back.
Okay, you can hear me?
Yeah, but there's a lot of background.
Let me leave off.
You have a radio on or something?
Is that better?
Yes, better.
Okay, so this is the video that you should not be seeing because I just woke up and the same called me.
Oh, don't worry about that. That's
Okay.
small things.
Good morning, everyone. So I recently started a job at a trust company,
Uh-huh.
having absolutely no background in trust, none. So I came from an events company, was there 13 years. And so this is one of the moves when I want to say you move out on faith because I applied knowing that I knew nothing. So
Okay.
I applied and I got the job knowing that I knew nothing. So that worked out. But now working in the trust industry, there's so much more to learn. And I realized that in order to move up within the company, if it's just a foundation, that is what is required to get up. So that's why I'm here. I wanna learn more and I like it. So
Okay.
far, so good.
Good.
Yeah.
All right.
All right.
Okay. What else you wanted to add?
That's it for now.
Okay, we have Lavette here. The other students send their apologies, but Lavette is in class, so Lavette will tell you all of this. You want to come around so they can see you. It's somewhere.
Hi, classmates. So my name is Lavette Baffel. Just like Alicia, right? Alicia. I recently started a job at Winter Brockham, and I'm a junior trust administrator. So also without a trust background. So I look forward to absorbing as much as I can. And that's about it.
Okay. All right. So I have 3 newbies.
Yes.
All right. And 2 without a book, but they'll get it later. So let's start first by looking or speaking about the international framework for trust business. So when you talk about trust, if you go to your book, go to the end of chapter 1, I think it's page 11. When you speak about trust, the laws that govern trust is quite a bit. First, you have the principal legislation, which is the Trustee Act. And I'm going to tell you now, so you know when we come to the next class next week, Saturday, that you should have already printed it and started to read it. So to study trust law, you have to know the Trustee Act. Then, in addition to the Trustee Act, we have the legislation called the Trust Choice of Governing Law Act. And that would govern the section in the trust deed that speaks to the law which governs the trust itself. In addition to that, you will have the Fraudulent Disposition Act. And that document speaks to the length of time a creditor has to attack a trust. You'll also have to know what we call the Arbitration Act. Because in a lot of trust deeds, when it comes to issues, there is a provision in the trust deed that speaks to arbitration. Rather than going straight to court, they have a step in between where there's an arbitrator who comes in to discuss the issues between the trustee and the beneficiaries or between the beneficiaries themselves. Then you have the Perpetuities Act and the abolition to that rule, and that speaks to the duration of the trust. And then, of course, it depends on the type of transaction that the trust is doing. Then you have the Exchange Control Act and its regulations.
Which one is that?
Exchange Control.
Oh, okay.
Act and its regulation.
What does that do again?
That depends on the type of transaction that the trustee is doing on behalf of the trust. So let's say if they're purchasing property in the Bahamas, they would have to go through exchange control and through the Bahamas Investment Authority. Yeah. So every time you venture off into something different, there are other laws that you need to be aware of. But for this course now, you're focusing on the Trustee Act and all of its amendments. You'll also learn that in order to do trust business, you need to have a trust license. And that trust license is via a licensing application, and I have the regulations here. I mean, the license application regulations, it says banks and trust companies license application regulation. That sets out the requirements to apply for a trust license. Once that trust license is received, then of course, the Central Bank of the Bahamas becomes your regulator. And then that means that you have to comply with the Banks and Trust Companies Regulations Act and all of its relevant guidelines. And of course, you know, once you're dealing with money, you know that you have to be aware of money laundering, acts of terrorism, and proliferation of weapons of mass destruction. So that means that you should have knowledge of the Proceeds of Crime Act, the Anti-Terrorism Act, the Financial Transaction Reporting Act, the Financial Transaction Regulations. We also have the Financial Transaction Wiring Regulations. That one isn't listed there. And in addition to that, if there is something suspicious, and for Nathaniel, you're going in the trust business, you're gonna have to hire a compliance officer. And that compliance officer can also be your MLRO. And they don't come cheap. And the legislation for filing that suspicious transaction is the Financial Intelligence Unit Act and its regulations. Now, in the trust business, you normally would have attached to the trust business a law firm or a lawyer who would conduct the legal side of it. In most instances, that law firm would have a financial corporate service provider. Your company has one. And that financial corporate service provider is where you would go to incorporate your companies. Whether that be a company that is going to be incorporated under the Companies Act or under the International Business Act, an IBC. And that financial corporate service provider would provide registered office and registered agent services on behalf of the companies that have been incorporated that form a part of the trust structure. Any questions so far?
I'm good. I just realized I'm gonna have a hell of a lot of reading to do.
No, not a lot of reading. Because let me show you. This page only has the listing. So you were not taking notes? You have to take notes.
Okay, I thought that was in the manual that you was reading from.
No,
I thought you was reading from the manual just now.
No, that's in my head.
Oh, wow.
Well,
Okay.
what you can do is when you read the first chapter, what I normally do at the beginning of each class, I would do a recap. And so anything you didn't understand or you didn't get from your notes, we can go over it. She go for it. Oh. Since you didn't write any notes. Alicia, did you write any notes?
Sure did.
Uh-huh. You see, Daniel? But you are free on two. Okay. Alicia and Nathaniel. Okay. That was Miss Dean popping in. All right.
Question before you move on. How long is this class?
Oh, now listen here. If we had started on time at 9:30, we would have been finished by 11.
Okay, no, because I was making my way to go to the come to the office to get my manual, and then she sent me the link to let me know class already start.
Okay.
So I didn't know it was today.
And how long would it take for you to get here?
Well, I could carry my laptop in the car. I just won't be able to talk. So I will be there in half an hour.
Oh, no, that's too long. That is too long.
Yeah.
Okay.
But I will definitely have my laptop in the car with me, so I'll still be listening.
Do you think we should take that route? Let him come.
How far is it?
You say half an hour. Where you coming from, Carmichael?
I'm coming from the Cable Beach area.
Oh, good God.
Maybe quicker than that.
That may be quicker than that.
Yeah, it might be, but I always like to give myself time. As a businessman, I learned to always give more time than I need.
Okay, hurry up and come then.
Okay.
You could use your laptop.
Okay.
Alicia, it's just you and Lavette for now.
Okay. Alrighty. Would you prefer us coming in on Saturdays? Because like now, as you would notice that I have two Zoom apps open, and it's because the internet is just garbage.
Exactly. Yes. No,
Yeah.
if you're available, then come.
Okay.
Yeah, because Lavette is here, and I know
Okay.
because I know doing my other Zoom classes, sometimes some of the students' internet goes down, but when mine
Right.
down, it is even worse. You see
Yeah.
what I mean?
Yeah.
So
Okay.
I always have to be worried about and so what I do is, even though the class is 3 hours, because I'm on Zoom, I have to cut it down because I don't know when someone could say theirs dropped or mine dropped. And
Right.
the longest mine has dropped, I'd say it's about 45 minutes, which is a lot.
Oh wow.
And I couldn't, and most of my classes are in the night. And I
Oh wow.
couldn't say like go on until 10. It's too late.
Yeah.
So I try to present and then I ask questions. And so as they drop off, then I know they already get what they need to get. No, but it's up to you. You can come in.
Okay.
Yeah.
I'll definitely come for next week.
Yeah. So it'll make it easier for you.
Mm-hmm.
Okay, Nathaniel, you can still hear us? Oh, he said, forget, he said he can't talk. He's just listening.
Yes, I'm making my way out the door.
Oh, wonderful.
Nathaniel was just ready to go.
Yes, he was ready to go. He should have made it. He should have been on the way from 10 minutes ago. All right. So if we start with the introduction, and I've written here that to get a sound and practical knowledge of trust business, the law and its administration, that's what this course is about. It gives you an understanding of the key players in a trust. All right. So the key players in a trust are the vet. You've been there 6 months. Who are the key players?
The settler, not that age. The settler, the beneficiaries, the trustee, the protector.
Okay, so these are the key people in the trust. At law, the beneficiaries, the trustee, and the protector. And we'll come back to explain who they are later. So to really understand trust business, you're gonna have to learn the role and the responsibilities and the duties of the various players in a trust. And more in particular, you're gonna really need to know those same skills that a trustee should have. And then you're also going to learn that out of all of these, it is the beneficiaries who have rights. So the trust itself was developed from equity. Now I need to drink my water. And equity means to be fair and to be just. And it all came from remedies that were developed over time and how to deal with persons who had legal issues. And those legal issues didn't fit into the normal remedies that a court would give. So the system of equity is less concerned with formalities, but is concerned with producing a fair result. So whenever you read a legal case, you will see where the judge is looking to be fair to the beneficiaries. So when you talk about trust itself, you have to be very clear of interest. So let me see if I can explain this to you. All right, you can see that, right, Alicia? Oh, she has it on mute. So this is a piece of land. A person who,
Yes, I can see.
okay, a person who owns a piece of land owing nobody. It is say they own it, fee simple, absolute, in possession. They owe nobody on this piece of land, and they have the land papers for that. Now, if you were to establish a trust, and this piece of land is a part of the trust assets, the only thing the trustee can take from this land is the legal interest. The equitable interest, no, not when it comes to trust. Equitable interest is the beneficiaries.
In the case like that is the senator designed his trust for two beneficiaries. And
You can hear Alicia?
the settler
Yes, I
died.
can.
Okay.
The settler eventually died.
Okay, so let me write it over here. Settlor, two beneficiaries,
And
he
let's
dies.
say- and let's say the beneficiary wants his wife or somebody like a child. And let's say they also both died tragically.
So
So
they die.
so now we have the protector of the trust, but with the who gets this land now,
Okay,
or does it go back
Um,
to his estate?
Was that
don't mix up
Will,
trust and will.
okay,
That's different law.
okay,
So for here, in this trust instrument, there will be provisions. And in this trust, it will cover all of these.
Oh,
In the event of the death of this one, where that goes. In the event of this one, where it goes. In the event of both, where it goes. It actually states everything in it.
So
Go
let
ahead.
me ask.
Mhm.
Okay, trust and will are two separate things,
Yes,
but so does the letter of wishes come under like a will?
no, letter of wishes is just another document, just
Mhm.
giving a thought of how you would like it, your funds distributed. So you'll have the letter of wishes. And then you have the trust deed.
Right. So the document that you should, the legal document to go by at all times would be the trustee.
Yes.
Okay. Okay.
Mhm. And with the will, so let's just say someone just died, but they left a will. They could have instructions to create a trust.
upon that.
Mhm. So in here, they would appoint executors and trustees.
Right.
And in here, they would say they want the trustees to create trust, sapodilla, soursop, lemon lime. And then they will say what assets are to go into these trusts. Then the trust will be created.
After they die.
Yes.
So in
You
that
could do it.
case, it's not a settler, because the settler passed away. Although he created the trust in his.
He
will.
still be the settler.
Oh, okay.
He's still a settler because the funds are still coming from him, even though
Okay.
he is deceased.
So his
So-
bank account would be open to those who are, let's say, the executors. or the
Now, when you say
trustees.
bank
Yeah.
account,
You
what do
say
you
them,
mean?
let's just say he'll still be in charge of like payments or
No, these
transactions.
people will do it.
Okay.
That's the trustees, right?
Yes, the trustees will do it.
Okay.
The
And
trustees,
then
the
Trust company.
the executors and the trustees are normally the
yeah,
same person.
Oh,
and that's where you would have like the estate of the late so and so and so.
Yes.
Okay.
Mhm.
Okay.
yeah. I didn't know
Alright.
that. Trustees were the same person.
Yeah, unless they write it otherwise.
Okay.
So when it comes to property, there's always a legal interest and an equitable interest. The two of these together, if you own it in fee simple absolute in possession. So if I would remove this, no, leave this because what's his name will need this, Nathaniel. If I were to look at this trustee here, the beneficiaries of this trust have equitable interest in the assets of this trust, whatever they are. Whether it's money, land, jewelry, a company,
Art.
they have equitable interests.
I didn't know art could have been of value too,
Yes,
to a company like that. a trust like
yeah, it has a value. And the trustee has the legal interests. So in your book, you will see that it says trust requires a clear distinction between legal interests and equitable interests. And you'll see why later. Because when I give you the definition of what a trust is, you will see
So
that-
fee simple absolution and possession, like you say, that's land. Equitable interest beneficiaries, that's money.
no, that could be land, that could be money, that could be jewelry, that could be art, it's
But
an
it does a
interest.
percentage of the shadow upon if it's equitable.
No.
I think
Yeah, you're going,
Equity.
no, it's
Okay.
a simple thing. Say this, go ahead, Alicia. thought you were saying something.
No, the internet was going in and out.
Okay. So say this building was the asset
Okay,
that the settler owned.
okay.
And he said he wants to put this asset in a trust. Okay? So he creates a trust. And he said, my beneficiary is boy one, boy two. So when the trustee is managing this asset, so this asset makes money, income. So when the income is produced and they send in the statement, they say, okay, the income for this year is 20,000. That 20,000 is then distributed to these beneficiaries according to what's stipulated in the trustee.
Okay.
The trustees make that decision whether to pay the beneficiaries or not. One, based on the type of trust it is, and two, based on the type, the determination of how much to give them. Sometimes the trustee himself would stipulate in here how much they must get.
Okay.
And in some instances, it is left to the discretion of the trustees.
And they could decide.
They could decide.
Ah,
And you'll see when it's left to the discretion of the trustees, it is called a discretionary trust.
Ah,
So in here, where this building is the asset, when you say the word trust, just by saying the word trust, looking at the parties to a trust that we have here, how a trust is structured is that the beneficiary always have an equitable interest. And the trustee always has a legal interest. That's the framework of what a trust is.
everything, the asset is given to.
All the assets. The assets are transferred into the name of the trustee, but the beneficiaries have an equitable interest, always. You got that, Alicia?
Hand over the asset to the beneficiary, the settler, that is. They just
Not hand over, follow the
follow the
instructions.
instructions, 'cause the trustee is just the middleman.
No, the trustee is actually the legal owner of the assets.
Okay,
He has legal interest,
okay,
but he doesn't have this kind of interest
okay.
because he doesn't own both interests. He only owns this.
So he does
The
that.
beneficiaries own this. So he can't do with these assets what he feels like. He has to follow the instructions from here. And if he is in doubt, he goes to the trustee act and then he goes to the court. So under a trust, the legal interest in the property and the assets will be vested in the trustees. And the equitable interest will be vested in the beneficiaries. And that vestment includes by way of income or by capital. And capital means that the trust assets itself. Because sometimes depends, let's say if your trust asset was about 6 different apartment buildings. The settler could have stated in there that when child 1 attains the age of 30, give them X number of dollars to start a business. Or it could say, purchase a condominium for that person. And depends on what it is, the trustee has to balance those funds. The trustee can't say, I don't have the money. Because the money is given to you to invest. And that's one of the responsibilities that they have. Because if the money is not there, then the beneficiaries will sue. And you'll see when we go further down that one of the trustees' duties, their duty to account. So the development of trust law and administration in the Bahamas has involved a comprehensive overhaul of the aspects of trust and the parties to a trust. And our trusts provide clients with flexibility. And also good protection. So it's normally seen in estate planning. So the existence of confidentiality and data protection laws which is these now are some of the features why persons come here to do trust business. So the existence of confidentiality, that is from the Banks and Trust Companies Regulations Act, Section 77. The one at the back, go to the back, the same page where you are. They have the Bank and Trust Companies Act. It's at the end of the chapter. Where your Banks and Trust Companies Regulations Act. But Section 77 is for confidentiality. So the existence of confidentiality and data protection laws, because we have the Data Protection Act. That's another act. No, it's not there. You have to write it. Data Protection Act. We also have a sound legal system, high caliber of professionals, stable political system, and of course, we follow the common law. And that enables administration of trust to be carried out in a consistent and dependable set of principles that protect and preserve the assets of modern day trust. So it is always critical that trust professionals are properly trained so they can administer and maintain the trust for their clients. And that training means that you must take a practical approach to study the application of trust law, especially as it relates to resolution of complex issues. The responsibilities of a trust officer are quite onerous. The development of a focused and analytical approach to trust administration is important to minimizing and mitigating the risk inherent in trust. And of course, we also have to adhere to international best practices. We also have to look at legal and regulatory requirements of customer due diligence. We also have to look at prevention of money laundering, terrorist financing, and financial crime. All of those things make a trustee's job challenging because he has to put all of these things into perspective. Then he also has to consider international tax. He has to think about inheritance laws. He has to think about forced heirship laws. So he has to be commercially aware of all of these.
What's that last one, please?
Forced heirship.
Something. Forced heirship law.
Yes. H-E-I-R-S-H. Heirship, yeah.
Forced heirship laws.
You know what that is?
Forced.
No.
Oh, inheritance. But I mean, if the person, let's say, the beneficiary, asks the trustee that they want their piece roughly, or they want their share of anything now.
No.
Okay.
Alicia, you know what forced heirship is?
Don't know that one.
Okay, so forced heirship laws refer to civil jurisdictions. As you remember, we are a common law jurisdiction. So in civil jurisdiction, a settlor doesn't make that decision as to where he wants his money to go. It's made for him, automatic. Civil jurisdiction. So that's why you see persons from civil jurisdiction, they would come here to the Bahamas to create a law where the governing law of that trust is the Bahamas. So in the Bahamas, the function and uses of trusts have been modified and enhanced through practical trust legislation. And there are many reasons why a person would want to create a trust. One is the obvious one, which is estate planning, and that's to provide for their spouse and their children. The next one is for when you have children with special needs. That's page 5. Not you there, yeah. With special needs, or sometimes you want to protect your assets from spendthrifts and wastrels. So that's mean, like, let's say if you have a child who's on drugs. You don't have to just leave them penniless. You can put it in the trustee that once this person has gone to rehab, recovered, and stayed sober or clean for 5 years, then they get their share. Yeah,
That's tough.
then it will go to charity.
Oh, okay.
The other reason why they would establish a trust is for investment purposes. So they could take the assets in the trust and then invest in other items. And how they do that is underneath the trust, they would create or incorporate companies. And the purpose of those companies would be to hold investments. So whenever they invest in an item, it would be in the name of that holding company. But the assets actually belong ultimately to the trust.
So there's like an umbrella then.
Yes.
So there's one trust, and then they have this company, that
Yes.
company, that company,
Uh-huh.
those companies invest in other. So, but everything still belongs
To the trust at the very top.
Wow. These trusts could do a lot, so.
Yeah, trust is just a vehicle.
Mm-hmm.
Yeah, that's how you look at it. It's a vehicle.
That's why
And-
you say you have to be careful in money laundering.
Yes.
What they invest in.
Yes.
Ah.
So on the trustee side, he's worried about money laundering, terrorist financing, proliferation of weapons. He's looking at all of those things, right? At the same time, he has certain duties that he's responsible for. We're gonna go through those. Those are his duties. Those duties is what the beneficiaries can sue him on if he doesn't do it right. Now, the beneficiaries have that right to sue. But at the same time, the beneficiaries are concerned about inheritance law because they don't want to pay a lot of taxes. So then you need a tax attorney also. Because it depends on where the beneficiaries live. And what's the tax regime where they live. And so sometimes you see the beneficiaries moving from one place to another place
And that's for tax purposes.
for tax purposes.
Oh, that's why it's also much different cost for than residency.
Yes. You heard that, Alicia? She said the debts are connecting. Yes, they do have lots of passports, a lot of them. And sometimes they do make mistakes and they send the wrong address verification. And you're saying, I didn't know you lived in Seychelles. And then it's, oops, sorry. No. That means you have dual passports or triple passports. Like, where exactly
So
are you
that's
living?
where the FATCA form and the W-8 and stuff.
The CRS form, all of that.
Ah.
Because the result for us is a filing. For the countries where they're from, it's for tax. It's
That's the
not-
factor filing and stuff that we do with the registrar general, I think there's a,
Mhm.
is that the registrar general? Okay.
No, the FATCA would go straight to the government portal. From the government portal, it'll go to the IRS.
Okay,
And then the CRS is the same way. It's inputted into the
same way,
portal,
right,
and then it's sent out to the various jurisdiction.
okay,
You have to have the right information because the countries then come back through the Attorney General's office with a subpoena. Yes.
so that's the same thing with, it's something I did yesterday. The central banking and the EU sanctions for money laundering.
Mm-hmm.
Central bank sent us to search the name of a client of an individual to confirm that they were not our client. That comes under that's not FATCA, that's just a UN sanction or something like that. UNS, what is it?
UNSR.
SR.
United Nations sanctions regime.
That's it.
Okay.
So that
Okay.
falls under money laundering.
Okay.
So what that is that large countries like the United States, like the European Union, they would, Canada, Australia, the large continents have a sanctions regime, which means that when a country doesn't do what they say they want them to do, they will put a sanction on that country. That sanction could mean that you no longer can receive any imports. That sanction could mean you cannot travel. That sanction can mean that your politicians are not doing what we told them to do. And so your politicians cannot transact business in our country. If you have a citizen who they classify as a terrorist, then they're telling you that if you have funds that belong to that terrorist, you have to freeze it. So they have no access to those monies. That's what the sanction regime is all about. If you don't do what we tell you to do, we'll force you to. But as you can see, those persons in the Middle East, that does not deter them.
No, they don't get up.
They continue.
This is powerful.
So people will establish a trust for wealth management, which means that you may have a, let's just say over time you accumulated a variety of assets. So let's say you have some paintings, you have maybe 3 yachts, 2 yachts. I mean, it is by these long things. You may have some condominiums, you may have houses, you could probably own a mall, a large corporation. And then you realize that guess what? My one financial manager can't do all of this. And if something was to happen to me, I don't have any protection. So then you take it and you put it in a trust where a professional will deal with it. Not saying that the trustee has all the expertise to manage the assets. You will see as you go further and you start to read the Trustee Act that the trustee can go out and seek professional help. So that can happen, but that's cost. Ah, he's here.
Yes, I'm here. I'm here.
At least he has arrived. That was not long.
No.
So they can also do it for financial planning. So the same example I just gave you, where he puts all of his assets within the trust, he can make himself a beneficiary while he's living. Yes,
Oh, wow, that's powerful.
he could make himself a beneficiary.
Wow. So what type of trust would that be? That wouldn't be discretionary.
Yes, it could still be discretionary,
Okay. Wow.
but you could have different types of trusts mixed together.
Oh.
He could have a discretionary trust. And again, the trustees will decide how much to give him based upon the performance of the assets.
Oh. So if they're doing good, then everybody get an extra cut.
No extra,
Oh.
because don't forget now, at the end of the day, 20 years from now or 25 years from now,
That's what-
his grandchildren can sue those trustees if they don't think that the assets were managed properly.
That's powerful.
And then, like I say, go ahead.
What are the type of dressing rooms we talking about? How to
We coming now.
help the umbrellas, right?
Mhm,
You know, certain trusts only invest in the stock market.
mhm.
What type of trust would that be?
It
Like
could be wealth management.
just a bunch of bonds and things and the Charles, it's like, there's not much you just see, like when you're looking at their, definitely not financial statement, their monthly statement.
Mhm.
Everything is the securities and the transactions, like, okay, this go to this bond, this was traded this place, and this was traded the next place, this got Apple, this got this got that. But it's no other, nothing else associated with that.
Probably just like a private trust. It's a trust.
Oh, okay. But they just more in the stock market.
Mhm. Those are just the assets.
Oh, they're
They're just the assets of the trust. And the trustee has to manage it. And that's about it.
And I know like there was a case where there's a particular trust we have and settler will tend to say they can make that out of beneficiary.
Mhm.
Some way he had access to his account. But his account he wasn't supposed to touch it. But at one point he started taking money from that account. And it caused a red flag because they thought it was money laundering.
Mhm.
Well, he didn't tell the trustee that, oh, he took the money from him. In his account.
But why would he have access to that account?
That's what I was thinking.
That's what
Yeah.
that's what they was trying to figure how he got
Access
access
to it.
to withdraw the money from his account. So I remember that was a special case.
But I mean, was that account a part of the trust corpus? You see what I mean? Yeah.
He wasn't supposed to do that, I know that much.
Well, if he wasn't supposed to do it, he had access, then something went wrong somewhere.
Yeah.
Someone gave him access that he should not have. So another reason to set up a trust is for privacy. And the last one is to avoid probate. Everybody knows what probate means, right? Yes?
So,
No.
And then can split up.
oh, yes, when you're in a will. And so, yes.
So if you have your assets in a trust, then you don't have to wait for probate.
Takes a long
The
time,
trustee, yeah, the trustee begins to act.
right away.
Mhm. So whenever you're creating a trust, there are legal formalities that have to be followed to create a trust. And we're gonna go through those later. Because in trust, this is a trust law class. There are cases that you have to know. So we already went through the parties of a trust, the settlor, the trustee, and the beneficiary, and the protector.
We are
It's 6.
probably movement from that.
Yes, we're going to page 7. So how do you establish a trust in the Bahamas? Well, you have to make an application to the Central Bank of the Bahamas using the license application. Yes,
Those 4 parts we just went through the trustee, the beneficiary, could you give it again? I want to write that down.
we can come to that later.
So you page 7.
Yeah, we're gonna come to that later. You don't have to write that down. It's actually on page 6. Close to the middle. The parties to a trust include the settlor,
Okay. I
that's
see.
the person who creates the trust, the trustee who holds the legal interest. Remember, we spoke about the legal and equitable interest while you were in the car. And then the beneficiary who holds the equitable interest, and then add to that would be the protector.
And, I will see that we have to establish what the protector is.
No, the protector is the person who the trustee will go to for advice in terms of the family. So let's say you're a beneficiary and you say, I want to send my daughter to St. Andrews. The trustee can say, based upon his knowledge, that wouldn't be a suitable school for the child. But let me speak to the protector, who is close to the family,
So that would be like a small, like a.
and
family
ask
friend.
them, yeah, a family friend, or the protector could be the settlor himself. And he can ask, and he can say, yes,
Trust. He's just doing it to me.
why?
The beneficiary, the settler could be everything.
Well, it
before he
is his
died.
money.
It is, but I mean, come on.
But it is his money, but remember now, not like the example you just gave, he can't go and put his hand in and take it out.
Okay.
I don't know. Sound like money laundering to too. Is that a money laundering on one side or stealing on the next side?
I have one question.
Go ahead.
Since the settler is the one who created
The trust.
the trust, and the beneficiary is actually the individuals who will be gaining the interest and so forth from it, can the settler at any time make the account null and void
Well,
once he set it up?
you'll see when we go further down, we speak about types of trust.
Okay.
A trust can be revocable or irrevocable. Yeah, we'll come to that.
And I think most rich, well, most wealthy people prefer irrevocable.
Yeah. Mhm.
So yeah, that's disgusting.
I don't know if I could find that case. It was. I'm trying to remember, I think it was revocable, you know. I think it was revocable. And the beneficiary, who was the son, was suing the trustee. Because the father revoked it. Yes. Yes.
Money now.
Okay, so to get a license, you have to go to the central bank via the license application. And there are different types of trust license you can apply for. You can have a public trust license, which means there are no restrictions. You can have as many trusts as you want. You can have a restricted trust. And that restricted trust means that there's only a certain number of trusts that you can actually manage. And then you could have a nominee trust license, or you could have a non-active trust license. So those two aren't really doing anything. So an unrestricted public trust license, they carry on trust business for domestic or international. It's open to everybody. And of course, they would have more reporting requirements, because then they're gonna have clients from all over the world.
It's like an IPO.
No. Mm-mm. Yeah,
Like where they could have business with members of public. With an IPO that's in the public or.
yeah,
But that's
People
the
get it
shares
back.
control of
that's
the
shit,
company.
yeah, yeah,
That's share.
that's shit.
There's trust.
Yeah, and those shares will fall under the Securities Commission. That's the
Ah.
regulator for that. Plenty things you learn in here, your head's starting to hurt.
No, not yet. It just like moving fast.
Now, when you're gonna have a public trust license or unrestricted, like how your company is, it is preferred that they are owned by a reputable company. Because what they're looking for is they want that framework already in place. Versus someone who comes in and they want to establish a trust company, but they don't have a framework. And that's where, from a regulatory standpoint, trouble begins.
Well, for me, how I'm just starting out, right?
Didn't I tell them I didn't want to dampen the spirit?
No, you're not gonna doubt me, trust me.
Okay.
But I started a management and consulting company, which is actually a venture capital company. And I'm presently trying to get investors for the startup capital. And I went a step further because what I realized with the Haymans, we don't tap into the financial vehicles that is available to the wealthy. And so I want to do whereas the Haymans can utilize trust, because we have the money in the country, but we don't utilize it properly. And so me starting up and
The problem you're gonna have right there, privacy. We're so small. See, I'm afraid to go to you to tell you I have
someone,
$3
so-
million. Mm.
Yeah. Yeah, because.
Not to say that the staff is going to talk it,
Yeah.
You'll see.
but yeah, but see now, when these people come here and they establish, when they establish a trust, let's say Mr. Snowman,
Mhm.
Mr. Snowman never appears here.
Yeah.
He doesn't come here.
Yeah, he just said,
His lawyer,
he is.
wherever he is in the world, will tell you what he wants.
Mhm.
That's it.
Yes.
The only way you know who Mr. Snowman is because you're gonna get his passport.
Yes.
That's it. So Mr. Snowman could pass you anywhere in the world and you wouldn't know him.
Yeah, but then you can do the same thing here, because even with the trust, you still gotta go through a lawyer.
I agree with you, but I'm still saying the island is so small.
But people create wills all the time, which is basically the same thing as a trust.
No, it ain't the
I
same
know
thing.
it's the same thing, but you understand what I'm
No,
saying.
people do not create wills all the time.
No, I know. It's a
Bahamian
big thing
people,
about
no.
us, yeah, but-
They ain't doing that either. As simple as that is, they don't want to do that. As
Exactly.
simple as it is as renewing your passport, they don't want to do that.
Guilty.
Oh, okay. So that's another thing. You have a brilliant idea, right? Because I see a lot of Americans have YouTube videos and trying to help people how to manage your wealth, how to get your wealth, what to do with it.
Mhm.
But that's a big country.
Yeah.
So I could sit down in Florida and I could call someone in Delaware or someone in New York
Mhm.
and no one know who I am.
Yes.
But in Nassau, it's small. So that's what you have to think about.
Yeah, I thought about that.
Yeah, that's always a deterrent. Even if you say, I'm a psychiatrist and I'm the best, right? People ain't walking in that door, I'm telling you.
That's the court segment.
And even if you put ankle monitor now, you you put the, hey, Lisa, you put the monitor on the cat, they're not coming. So you still have to think about the mindset of your proposed clientele
Yeah. But
from
I
a
already
business
know-
perspective.
I already know, my clientele behaviors wise only can be about 20%. I really think
Yeah,
that-
it ain't gonna be that much.
Yeah, I do it 20%. I give them the benefit.
Okay, all right. So unrestricted trust license,
20% for Bahamians.
yeah, he said 20% of his portfolio will be Bahamian clients.
Oh,
I don't want to dampen the spirit, let him stick with
Yeah, it's a
20.
challenge.
He
Yeah.
knows- Yeah, he
I'm
knows,
challenging
it's-
myself.
he's challenging himself.
not bad at all.
No, go ahead. So normally, if you come in for an unrestricted license, it's 5 shareholders. Of high net worth. Really high. So they would do their due diligence on those individuals. So you can have a net worth of, say, 2 million. And your investment in the company is 1.5, you broke. You see what I mean? Because you only get half a million, you only have half a million left to float on. So you're talking about having real money. What else? If you apply for a restricted trust license, they're normally limited to just managing 5 trusts. And then based upon your expertise, they could even make it less. So a nominee trust license is for nominee services. And they could be for holding securities and assets in a licensee name, or to provide for corporate services, directors and officers. So if you know how the corporate service business work, right?
I know, yeah, all profit department.
Yes,
They were fine.
yes.
I mean, no, I'm.
Do you know what they do?
A lot.
No,
I
besides,
mean,
yeah,
Corporation,
of companies.
of company.
Mhm.
I know they do a lot with, they reach out to a lot of the clients,
Mhm.
the registrar, they do a lot with the registrar.
Mhm.
And, I just know it's a lot, and emailing the clients back and forth. like
Mhm.
all the-
So in that structure.
Sometimes they get up from 7 o'clock and it's 7 o'clock.
Probably 10.
And they don't even take much break.
No care, because the clients keep coming.
Mm.
So let's just say,
Every people is some of the most difficult people to do.
And a lot of them do too.
because they have money. Okay, so you have a license to do banking and trust business or just trust business. Regulator, central bank. Now, you'll find out that these clients want to manage their monies in different ways. So yes, you have a trust here. Yes, you have a bank here. But they may also want to do other business. So within here, this bank will apply to this regulator for a license to do this. Financial corporate service provider. And this will allow them to incorporate IBCs and what we call a CAC, a Companies Act company. Now, these in here means that when they incorporate these companies, they have regulatory filings and statutory filings. That's why they're busy.
And people stop with that.
Yeah, because you have a company and the company may be just for one purpose. When that purpose is finished, you may say, okay, in the articles, there's no limitation on the duration of this company, but I no longer need it. But he say he needs a company. So he buys the company from me, transfer the shares. So that's what this is right here. That's what they're doing all day long.
So,
Or they're appointing directors and appointing officers, changing.
so question, like how I have my venture, my management consulting company already formed, right? Would it be better for me to have a trust department or just open up a complete trust company that is owned by the management company?
The issue that I have, you know, put a trust department here.
Into already existing company?
That's what you're looking at, right?
Yes, sir.
The problem I see you having is the same one I said at the very beginning. You have to go through a regulator.
Okay.
So before you even speak to investors,
Mhm.
you have to see if the regulator has the appetite for what you want to do.
So the best thing for me to do.
See, because to go into this business,
Uh-huh,
you need plenty of this.
yeah,
And you need to have the professionals with the experience in this. They're not gonna let you open this with someone who's only been working 2 to 5 years in trust.
okay,
You
so,
need real experienced people.
so from what I'm gathering now, is best I outsource my trust already to an
And
existing
existing, yes.
trust company
Uh-huh.
and just.
Set up
I
an
be the
arrangement
middle-
whereby you, yes,
I'm the middleman
you get a
between the
fee
client
for
and
referring the
trust
client
company.
there, yes.
Okay, so,
Yeah, you getting it? Okay, I didn't want to dampen your spirits.
no.
But
that's
I
why I'm
wanted,
here.
I
That's why I'm
wanted
here.
to make it clear
Yeah, man.
before you go down the road
Yeah,
and then you say, well, I went to that whole class and she couldn't tell me that. When I would have walked into the door
that's right.
at the regulator, they was gonna just say, can't happen, bye, see you.
Yeah, I'd be
And
the
you
middleman.
didn't put all your effort into it. But I
believe
couldn't
somebody-
dampen your spirit over the internet,
Yeah.
right, Alicia?
So you're thinking,
I couldn't dampen it like that. So this here can decide that they want to go to the central bank and they want to apply for a nominee trust license.
that's
And that can be another company that is owned by them. And they use this company to provide services to these companies here. So you will see when you look at some of these companies that they have directors. And that company name is on it. Or the shareholders of these companies can be that nominee company.
And I just noticed that I was able to do the SASHA filing,
Mhm.
and you can go and see who the director is, who resigned, and who's the new shareholder. So like you say, a lot of them
Mhm.
have 2, 3 directors, sometimes 5,
Mhm.
and then shareholders will be 2.
Mhm. In most instances, they're one.
Yeah, most is 1.
Mhm. For an IBC, they're normally just one man. He's the shareholder, he's the director, and he's the officer.
And he becomes a secretary with somebody else.
Sometimes.
Oh, that's in the trust company.
No, these are just regular companies that are underneath the trust.
Incorporated, I thought incorporated companies, you have to have the director, the treasurer, the secretary.
That's under the CAC. Not under an
CAC
IBC.
is
Okay.
Companies Act, yeah.
So CAC is more, so it belongs to trust. As
Mm.
opposed to corporate,
No,
no,
no. The IBC is
international.
yeah, but it is a more flexible form of a company. Because there's less filings with the registrar. It's flexible, because I, as a foreigner, I can have my lawyer call here and say, my client, Mr. Joe Black, he wants to incorporate 5 IBCs. And these are the potential names.
And that's what corporate would deal with.
And corporate then will incorporate those companies in those names and
But
send
the
the names.
trust would just deal with what Joe Black has initially set up.
It depends. Okay, let's just say Joe Black has a trust.
Mhm.
And he decides that he wants to incorporate some companies to hold investments. Then they will come under the trust. But then the trustee will make the decision on the names.
Okay,
Don't forget now, the trustee has the legal interest in the assets.
that's that umbrella again. we were talking
Yes, yes. So I have on page 8, I say, promoters of a proposed license normally prepare a letter to the governor of the central bank and outlining the reasons for a trust license, any long-term plans or objectives with regard to the company. So you will find out, if you read the Companies Act, that there are certain words that cannot be in a name if it requires a license. You have to get the approval first from the regulator, who more or less owns that license, that name. So if you want to do trust, let's say you didn't want to do trust business, but you wanted to have a brand where people would trust what you do, you can't use the word trust. No. There's certain words you cannot use in a name.
But I thought by having trust in your name,
If you're doing trust business, yes.
uh-huh.
But if you're not doing trust business, you can't have trust in your name.
Oh, okay,
Right.
yes, that's understandable.
Yeah. So the minimum capital is $500,000. And that's to be a wholly owned subsidiary of an existing financial institution. And of course, if not, is a higher capital. So the minimum capital for unrestricted bank and trust together is 5 million.
Okay, so basically, I could open up my trust company, but I have to be doing business for at least 3 to 5 years consistently to show the financials that I can deal with something.
Yeah, but remember,
According to-
yeah, but see, it's not just, what you mean in your regular company, your
Yeah, my
management
reg- yeah,
company?
yeah.
No. You, if you want us, okay, their preference is an established bank or trust company already,
Oh, okay,
and you're coming into the Bahamas and you want to operate a subsidiary
okay,
of that company. If you come here as a standalone, let's just say your shareholders could be one thing. They have the money. But then you have to prove to them how you're going to run this. So you're going to say, I have Mr. Joe Swain, 10 years trust administrator in Cayman. I have Ms. Susan Blue. She has 12 years experience. She worked in Jersey at bank so-and-so doing trust. You got people who are reputable.
yeah, that's why I say 3 to 5 years. to build.
Yeah, but they can cost you money,
Yeah, well, I know that.
lots of money. So the fees aren't too bad. I have the fees here. And of course, you need to have professional indemnity insurance. And then only thing I've done here is list what the application requires. Your name on page 9, the address or the registered office, the financial year of your trust company, the name of your auditors, who your shareholders are, where they live, their nationality. They also need the character references, financial reference, the CVs of those persons, their financial statement, and their police certificate. Then whoever's the managers or who are going to be the directors and the officers, it's the same thing. They need the character references, they need the financial reference, and they need the CV. Then they want to look at the capital of the company. They will ask you for all the corporate documents of the company, the act, the charter, certificate of incorporation, the memo on arts, partnership agreement if there is one. Statement of the capital of any company that is held directly or indirectly underneath that company. They're going to ask you about your internal controls, and they will need a business plan. There's quite a bit involved. But before you even fill out that application form, you have to have a conversation with the regulator. All right. So. Should we start chapter 1? Yes? All right. So chapter 1. So remember I told you that trust is, go ahead, Alicia.
One quick question.
Go
Would I
ahead.
be able to get this class email to me? I see that it's being recorded because this internet is going in and out and I'm missing a lot. Like I'm switching between Wi-Fi and data, just in
Yes.
case I miss something important.
Yeah, it's being recorded. I'll just tell Ms. Dean to make sure you get it.
Okay, thank you so much.
Okay.
And do you know what time they close there? I could possibly go and get my books today.
Did she say, Nathaniel? What time? Oh, she said 12.
Okay, all right, thank you.
So you will make your way down here too now.
I need to.
Well,
Is-
it's 11, 15. Just leave it open. I'm not
Okay.
gonna be, I won't be too much longer. I'm gonna stop right at definition of a trust.
Mhm.
Because then you'll have your book, because she's at a disadvantage.
Yeah.
You can read the introduction, and then we'll do unit 1. You can see unit 1 is a little bit long.
Or is there Hey, let me ask Nathaniel, the business owner. Nathaniel,
Yeah.
you wouldn't be after you leave from there. Would I be able to meet you on the road just to get my book from you in case I don't make it in time, please? I could come to you.
I'm going in the East Street South area when I leave.
Perfect, perfect, perfect. I'm in South Beach.
Yeah.
Okay.
Okay, so hold on.
Yeah.
So tell her where.
Let me just give her my number now.
Okay.
Okay.
Go ahead.
802
Uh-huh.
99
Uh-huh.
69.
802-9969. And let me give you mine, please.
Okay, let me
557.
hold on. I'm
He's
taking
putting
my
it
phone
right
out.
in his phone.
Okay.
What's the number?
557
Mhm.
2048.
2048. Okay, I'm calling your phone right now.
Okay.
Oh, I forgot I gotta talk up.
So.
I will zap you. And then we go
Yeah.
from there. 802-9969.
Yeah.
All right, sorry about that. Okay.
Okay, so as soon as we say school is over,
Uh-huh.
WhatsApp him right in this building before he leaves.
Okay.
All right, because I don't want to go too far since you don't have your book. I know it's difficult. What pages you doing in?
I just looking at it.
She-
But all I gotta read it.
You have to read the whole book.
I know, maybe it's the next week.
Or we don't have a class schedule, eh?
Huh?
No, okay, then let me stay and finish that and send it to you. So you can know which units we're doing for each class, okay? Okay, so like I say, trust in its modern form came around after the 1700s. And like I said, they developed, yes, and like I said, they developed a system of being fair and being equitable. And based on that, there were certain what we call rules that they use for coming up with the judgments that they did. And you will normally see these rules written when you read a case. But if you know what the rules mean, then you'll see when they come to the decision, which rules they apply. So the first one says equity will not suffer a wrong without a remedy. Which means that when you go before the courts are going to figure out what's the best remedy to give you. They're not going to leave you with no remedy at all. The next one is equity follows the law. So whatever the law states, that is what the judge will follow. And if, let's say, if you brought a matter before the court and you left out some information, the law is not going to put that, the judge is not going to put that information in there. You have to follow the procedures. And you see that a lot when you read cases, when the judge says, but you did not include that in your submission. It's out. Third one is where there is equal equity, the law shall prevail. And so that means that if both are at the same level, the law then looks at the law and see who should get what, or who is in the right. Where the equities are equal, the first in time shall prevail. So that means that if there is a matter with a piece of property, I say I own it, Nathaniel says he owns it. What that equity rule means is the law says whoever was the first to register that ownership is the owner. It doesn't come with who paid, you know.
Who registered?
Who registered. Remember, that's what law is. Law follows a process. He who seeks equity must do equity. So that means that fair is fair. He who comes to equity must come with clean hands. So you cannot come to the court asking for a remedy, knowing that you have done more injustice or wrong. Delay defeats equities. So that means that you cannot come to the court for a remedy if the time, the duration, the limitation period has expired. It's gone. Equality is equity, which means looking at things on an equal footing. Equity looks to the intent rather than the form. So equity in looking to the intent means that everything always in law goes to the intention. What was the intention of the parties when they entered into this arrangement? Equity looks on that as done, which ought to be done. So if you go before the court and you say, this person needs to give me this. The equity looks at, to be fair to the other person, what is it that you should have done, that you didn't do, that you ought to have done in order to have this finish? Equity imputes an intention to fulfill an obligation. Again, intention is in the mind, looking at what was the agreement between the parties and what was the obligation on the parties.
Okay, I have one question.
Mhm.
So what if, say, XYZ, someone owes somebody X or Y money, but they didn't have a written contract, they had a verbal agreement, and Y completed the work, but X ain't paid the money, so Y carry him to court, and X denied their verbal agreement. There's nothing written in law to say that that was agreed.
No, but now, based on your example you just gave, you move into a different law.
What type of law is that? Oh,
You move into that law.
Yes, contract law, but there's nothing written.
Doesn't matter.
word of mouth.
But that's it. You
Verbal.
say, that's
Hold
what
on.
you say, I say.
Yeah, but hold on. Whether it's written or it's verbal, there are certain elements to say that you have an agreement. And there's certain elements that make it a contract. Agreement and a contract is two different things.
Okay,
So the first thing is an offer has to be made between the two parties.
yes,
I want you to do this for me.
yes.
The other party must have accepted it.
Mhm.
I will do this for you for $50.
Yes,
I'll put here mow my lawn.
Yeah.
That's an agreement.
Mhm.
Then there is consideration. Consideration can be two ways. Act done. Money paid. So the consideration here is this person who accepted is going to do this.
Yeah.
It's anticipated that he will be paid.
Yeah.
Now to move on to being a valid contract. Whenever you speak about a contract, certain elements are more important than others. Now that he refuses to pay, the question comes then, did he intend to create legal relations? Were they of the same mind? Did they agree that I mow, you pay?
That's the first
That's-
agreement.
That's just offer and acceptance.
Okay.
This is here the money after the act is done. This here now comes to, remember, law, everything, most things to do with law goes with what's in the mind of the parties at the time that they entered into the agreement.
so what if, the person gave 25 and they only owe 25, so that will basically confirm the agreement?
Yes, yeah, you've already started to pay.
You already give.
Uh-huh.
So you owe. So the person who was suing for the next 25 on legal grounds,
Yes,
even though it's verbal.
The question would be asked, why did you give them the $25 if there was no
exactly. If
agreement?
you, right, because that's the question. Why would you give $25 if you didn't intend to give the balance, knowing that that's the agreement?
Yes, no, because I see, my thing is, I know that in law, it normally, if you have a written contract.
No,
you
no.
Understand, I didn't know.
It could be verbal or it could be written.
Okay.
But there's certain contracts that must be written
Yes,
by law.
yes,
But if you just, okay, if you're building a house, write it.
yes, you definitely.
You need to write it. If you're selling a car,
Yeah.
write it. As
Because
is.
you transfer ownership.
Yeah.
Yeah,
But people like who want that things for sale or whatever, selling this chair here and that other thing, it's a verbal agreement.
Yeah.
I'm selling this chair. This is the condition it's in. You're buying it as is.
as is.
$50. I agree, $50.
Mhm.
When you carry that out there, don't come back.
Yes, so,
Because I said, I offered, you accepted,
mhm,
you paid me my $50.
mhm,
And at this time, you said, I want that chair.
okay.
You didn't say, I'm not too sure, See, that's why you have to be very careful. Because when a person says, I'm not too sure, and then they still give you $50, they coming back.
So you gotta. make
See,
sure they-
because this is important.
So you gotta make sure they show.
Yes, you have to make sure that they are sure.
Yeah, I understand.
That's like if you get your hair done, right?
Mhm.
So let's just say, tell a barber you want to have faded a certain thing. Mine, you ain't faded nice, but it ain't really like you want it. So you give him the money. Then you say, man, I need to go back to him, you just need to fix your hair.
Yeah,
Come up and say, man, I tell you I wanted it. You're supposed to pay me.
and then you gotta do it for free.
And
Yeah.
exactly.
Yeah. I mean, like.
Okay. And then the last one is legal capacity. Whether or not the person was over the age of 18, or the person wasn't drunk, or the person wasn't high, or that the company itself is still in good standing. Remember that. But if you do business with a company, it has to be in good standing.
Yeah, but in case of more than one, that's person to person.
Yeah, that's person to person. I'm just letting you know.
Okay,
Yeah.
So what happens in the case too, like if you have a trust, right? And
Mhm.
you wanna pay that trust fees. Like the fees that the company assigns and it like.
What you mean they don't want to pay you up a contract?
Yeah, but let's say they didn't pay, or they just like, this issue right here, let's say they just say, okay, they have a bill of 100,000
Mm-hmm.
and they pay 50.
Mm-hmm.
But you kind of balance off your financials by the end of the year. Your accounts receivable and they don't, they say, okay, yeah, we keep asking very much, so when you gonna pay the other 50? Yeah, I'll pay that soon, but then they don't.
But what are
pay
the
you.
provisions in the trust deed
I guess
or the
that's-
contract with the settlor? You see what I'm saying?
Ah.
Everything, if it's verbal, it's he say, and then I say.
But the
But
deed-
when it's in writing, that's what you go to. And if in that contract, they did not put a clause in the event that the settlor cannot pay, then you'll screw yourself.
yeah.
Can we let them run up so much money? And then.
And you should have put provisions in there to protect yourself.
So the trustee has to also, that's why it's important, the trustee, like you say,
Mhm.
the trustee is what covers.
And I'm gonna give you all a copy of one next class of a
Okay,
trustee.
because if that mess up, when that
Yeah.
said, look,
Mhm.
anything.
Mm-hmm.
'cause
You
it
pay when you
says
feel
these
like.
sounds.
So what's a trust? It's a legal binding arrangement in which a person, the trustee, he holds, he manages, and he administers the assets. Holds, manages, and administers the assets that were originally owned by the settlor. And the settlor transfers it to him. And he does that on behalf of the beneficiaries, of whom he may be one. So if you look at the long definition, it says a trust is an equitable obligation. And you know what I mean when I say equitable obligation? Lavette knows. Do you know, Nathaniel, what I mean by?
Yeah.
What?
And you say a trust is an equity, meaning that it has value that you can benefit from.
Right. So to say it in another way, an equitable obligation means that a trustee is obligated to the beneficiaries. It's binding on a person, that is the trustee, to deal with property over which he has control. Because he holds and he manages and he administers the assets. And he does that for the benefit of the beneficiaries, of whom he himself may be one, and any one of the beneficiaries can enforce that obligation. Once you are a beneficiary, you have the right to sue. 14?
Okay, so that brings me back to something that okay. If you have an executor that is holding a trustee, a trust, where I say, for instance, that all of my heirs and successors, even my children, my grandchildren, my great-grandchildren, like you said, but St. Andrews, go to St. Andrews, right? But the executor, which is the child of the settler who created the trust, and they only sent their kids to St. Andrews, but his brother children and their grandchildren and great-grandchildren, they don't benefit from that. Can they sue them for that?
As long as they are beneficiaries, they can sue. The beneficiaries have the right to sue.
The executor, okay.
Remember too, she said too, remember the example she gave earlier, she said, let's say 20 years down the line.
Yes.
That
yes.
also,
Yeah,
maybe
that's
like
true.
you didn't handle the assets, right?
Yeah, you'll be sued.
But could you put it in the trustee?
No, this is by law.
Okay.
This is by law.
That's by law.
Because you'll see when we go to other chapters that a trustee has duties.
Okay.
Like how you're just starting out and you get promoted. You go, you get, as you move up, you get more job, more responsibilities. But these duties are not written in that contract. These duties are inherent in trust. These go with that name, trust officer. And those responsibilities lie within that title. So no one is going to tell you when you get promoted to trust officer, oh, you have a duty to account. You have a duty to do that. They're not going to tell you that. They're just going to give you more responsibility. But underneath that responsibility, you have duties and you can be sued. Now you have the protection of the company. So when they sue, they'll sue the company. But at the end of the day, if the company is going to incur a loss or its reputation is going to be damaged, then it's going to look to the officer that carried out the action that caused them to be sued. And if you lose your job because of that, then you can't enter the trust business again.
What?
No, nobody trusts you. Then we start out the first thing when you reach trust. T-R-U-S-T. Trust. So it's just as if you're a banker and you steal quietly. What did the banks do? Now they don't do it anymore. But before they just let you go. They give you a little check and then you go. But if all of those thieves over the years, they would have been labeled as thieves all around the world. Yes. Now, one or two persons who know them, when they come across and say, that one's a thief, They steal $200 from the bank. Yeah. That one, they steal $300. But nowadays, when you take money and you spend that money, it's money laundering. Based on the last legislation. You steal that money and then you spend that money, it is money laundering. So you're not only a thief now, you're a money launderer.
Wow, that's powerful. And now it's on your record, eh?
Yeah. But before time, like we said, because the bank was protecting its reputation. You see, again, it's a matter of trust. So yes, it comes back to trust.
Yes.
You see? Because when I give you my money, even though in banking law, that's not my money. Once I give you that $20, I can't come back for that same $20. You could make a demand for $20, but not that particular $20 bill that said VVMX. No.
Yeah.
You make a demand for it. My credit balance should be $20. I want my $20. There's a difference. So that's what you have to think is a matter of trust. So the bank is looking at its reputation. And then it has to look at its brand. If its brand becomes synonymous with distrust, people are not coming to deposit. If you don't have deposit, you cannot lend. Okay, so they quietly let you go. And that's why you'll even see people where you were. Depends on what they do. Will you go, they find another person today? They're like, oh, another person today? But you don't know the reasons why. And they do that because the island is so small. You see? So you could get another job somewhere else.
Oh, but the executives never talk to each other.
Yeah, but when they call for reference,
Yeah.
it depends on what you did. You see? And that makes a big difference. Now, let's just say there is some missing money, and then we had to hire an auditing firm, and we had to do some investigations, and you waking every day, and you know it is you. Well, you know, that's it for you. The police coming for you.
You better pay that.
It would have been better when you saw them starting to investigate, to come clean.
Yeah.
And you save yourself that embarrassment and get a job somewhere else. Okay, so type of trust. A trust may be classified into several categories. This is your question, Levette. You could have a simple trust, a special trust, a statutory trust. I mean, that's a trust created by law. You could have an express trust. Express trust means that a person just walks into a trust company. I want to establish a trust. That's what express means. An executed trust or an executory trust. Executed means that they've signed, all the formalities have been done. Executory, we'll come to that one later. Completely and incompletely constituted trusts. Private and public trusts. You have a discretionary trust and a fixed trust. Fixed trust means that the payments to the beneficiaries are already stipulated. A protected trust. Protective trust. You can also have secret trusts. We're gonna come to that later too. Yes, secret trust where the beneficiary doesn't know that they are a beneficiary.
Oh, wow, it's how the person died and then it's like this. they
Someone
found some,
calls them, yeah.
Property.
Mhm.
Oh,
We have a charitable trust. You got a purpose trust, trust established for a particular purpose. You could have implied and resulting trusts, and those are not actual trust by purpose. Those are trusts that arise by law. And then you could have a constructive trust, again, by law. So when you think about trusts, you always have to distinguish a trust from other arrangements. So a trust is different from bailment. You know what bailment is? No,
Money when you do something wrong.
no, not bail,
Okay.
not police bail.
No, you don't know.
No. Bailment is where you have property and you're giving it to a bank to just hold, like a safety
That's
deposit
the whole
box.
thing.
Like a safety deposit box.
Yeah.
That's bailment.
Okay, so since they're holding the property, do they maintain it?
No, they have a duty to ensure that whatever that property is that you give them to hold, that it's in a secure place, that the holding space is conducive to the property, and that its staff does not convert it. Which means that the staff cannot steal it, and the staff cannot give it to a wrongful owner. You can sue the bank if they do.
So that's only for trust?
No, we're trying to distinguish between a trust and other arrangements, because some people call everything a trust. So because I open up a safety deposit box in the bank, and I put my jewelry in it, or I put my land papers in it, or I put my gold bars in it, I put my coins in it, they believe that you're holding those things in the bank on trust. It is not.
That's
It's
holding,
bailment. It's bailment.
Just holding it. It's
You're
not
just holding it.
trust.
No,
So if something happened to that, that ain't on the bank.
no.
Let's say
The
the bank
son-
get burned off.
You have to have insurance.
Oh.
Yeah, but if, let's say someone comes and say, box number 123, maybe they was in the house cleaning up, they saw it or whatever. I lost my key, I want to take out my stuff, but you give it to the wrong person. You could be sued. Now, so a bailment and trust they differ, even though they appear to be similar. There is a difference between the two.
Yeah.
So even when you see companies go to the bank to make a deposit in the night and they drop it in a chute, that's bailment. It's holding until in the morning, when they open it and count it, then it becomes a deposit. But just shooting that, that's bailment. That's why you see this, we looking left, right.
Then you have to record what the value is. and
Yeah,
everything is
but that's why
back
they do it very quickly.
Yes.
And rent.
Oh, yeah.
Somebody come up with you.
Okay, so bailments could only be made of chattels. That's goods, you know what I mean? Like I say, jewelry,
Yes.
gold bars or whatever. A trust could be made for all forms of property. There's no legal title and property is passed with bailment. But in a trust, legal title is passed with the property. In a trust, the trustee has legal title. The trustee has no rights, but he has duties and obligations in dealing with that property for the benefit of the beneficiaries. So agency. Agency relates to principal and agent relationship. So principal and agent is, let's say you have a company, you notice in the paper when they'll put a picture, a big picture, and they'll say, Amos Ferguson no longer works at this company.
Yes.
That means that Amos would have acted as an agent of that company. So he probably might have been calling around, getting contracts, following up on jobs that were done. He, in that capacity, he acted as an agent of his employer. That's the principal-agent relationship. That is different from beneficiary and trustee. Totally different. So that trustee and that beneficiary, their relationship is a fiduciary one. And that fiduciary one means that that trustee has duties. Whereas under the principal agent, it's different. It's totally different between the principal and his agent. So the trust relationship is proprietary, and while an agency relationship is personal. An agent has possession of the principal's property, while a trustee has a bare legal title, because the equitable interest belongs to the beneficiaries. A contract, and we just did this with Nathaniel.
Yeah.
A contract gives rise to personal obligations which are enforceable in law. Another part to the element of a contract that is not one of the, this is the main part. And then we have other requirements. And one is privity of contract. And privity of contracts means that only the parties to the contract can interfere. So say this was between Adam and Joe. Mary can't come as the wife of Joe to talk to Adam. Not for this $50. She's not privy to this contract. It's between.
So that's something like an ASU then, in a way. So let's just say, because ASU is not okay. So in a sense, you're the ASU,
Mm-hmm.
I'm the ASU,
Mm-hmm.
and something happened to me. And my mommy now like, oh, it's supposed to be the best child, well, money. So my mommy, like you say, she don't have a say because I.
She's not
made
party
that
to the
agreement
contract.
With him, so she
Mhm.
can't get what was supposed to be
No,
mine.
no.
So in that event, he would just keep it.
No, whoever is the master of the ASU
He's
keeps
the
it.
master.
Yeah, then he'll keep it. He has to give it to you.
If I die,
Then it goes to your estate, so you'd wait for the probate.
okay.
So he'll still hold it.
Okay, so I still hold it, but wouldn't it go to her next of kin?
No. It depends on whether or not she has a will or not.
And I
If she
don't-
has a will, the executor could come to you for the money.
Yeah.
If she doesn't have a will, then they have to wait for probate. In both instances, you need a probate. But when you have a will, the executor begins his duty right after that.
that is-
But if you don't have a will, you have to wait for that piece of paper.
You know, a lot of people in zoos and they've been in those for like years.
It's a contract.
Yeah, 2 years.
It's a contract. Before it used to be by word of mouth, it's now by contract.
After that.
Mhm. So a contract is enforceable if there is consideration, you know, what consideration means either the act is done or money is paid. Or it's done under a seal, such as when you purchase property, it's done under a seal. However, trust is enforceable by a volunteer if it's completely constituted. That means sometimes there can be a person outside of the trust who can sue the trust.
Once it's pretty young.
Yeah. So a power is an authority given to a person either by instrument or by statute to deal with or dispose of property in which they may have no beneficial interest. And powers are in two kinds: power of disposition over property and power to deal with property. And you'll see sometimes within the trustee, the settlor would give a power to a certain person to deal with a particular property. Or he could give a power to a certain person to appoint new directors of companies.
But I wouldn't be given to the protector.
He can, yes, he
or-
can.
But he can't appoint the beneficiaries to do that.
No, but in some instances, I've seen it in some old ones,
Oh, okay.
where they'll appoint one, or they just appoint a relative to do it. So power of appointment are usually given in trust, and they enable the trustees to provide funds for the beneficiaries in circumstances that are unforeseeable. And see what I have here, they could appoint sometimes children or grandchildren, things further down the line. Power of appointment just in the event that something happens. So a power, again, differs from a trust. A trust is imperative. A power is discretionary. So when you see in a trustee, it says power of appointment, that is discretionary. And depends on how it's worded. That means that that power can be executed or it doesn't have to be executed. So one is directed and the other has no obligation to act. A trust is equitable, whereby a power may be legal, such as a power of attorney. A trustee is a fiduciary. A holder of power may not be a fiduciary, because there are some cases where a power was held to be a fiduciary. It depends upon the act that he's carrying out. A trustee may not release his trust, but a power may be released by the holder. So you could have a power of appointment, but how the clause is written you could release that to the person who's holding the property. So the parties of a trust, we've done them before, and this I was telling you, was coming to them, Nathaniel. So the settlor is the person who creates the trust. And the settlor has both interests. Because in order for him to transfer property to the trustee, he must have both interests. And having both interests means what, Levette? He has what? Yeah.
Oh, to find out.
Fee?
Fiduciary.
No, fee.
Fee, I know we just did
She
it.
know it.
Right, yeah. Fee. Right, right, yeah. Fee committee.
No.
Man, I write it down.
Okay, tell me what it is.
Fee simple, absolute.
In possession.
You did that? Yeah, I missed that one.
Yeah, this is what you can. The line and the trustee is.
So you have land. Land has two interests. Legal and equitable.
Yes.
Both of them together means you own the land in fee simple, absolute, in possession.
Simple.
Absolute. In possession. So when the settlor is creating his trust, his assets have to have both legal and equitable interests. When the assets are transferred into the trust, the settlor takes the legal interests. And the beneficiaries have the equitable interests.
So just a scenario. So if I have a $2.5 million home that I don't never want my children to sell, but I'm still paying mortgage on it. Can I put that into the trust and have the trust continue paying the mortgage? And then after the mortgage is paid off, it remains in the trust and it's an equity for my generation. But not
But
that I
how,
can
but
now
how,
sell
but
it.
how we paying the mortgage?
No, if it's in a
With what
trust.
money, yeah.
Yeah, I know, because trust has other monies coming in.
Oh, well, yeah, yeah.
So, but I don't ever want them to sell this particular house because I build this as a legacy that my generations can always sell something that they can call home.
But in a trust, I wouldn't landlock that like that. Why? Because
I can't see that.
what do you mean you can't see that?
No, I never cited, sorry. I never did that. Let me come up.
This is the first thing I read on
Oh,
the budget.
nobody
yes.
wants that. Okay, yes. The crowd always wants the lot. I know
Yes,
that.
the
Crowd-
only thing you have is an interest in land.
Yes,
So I say that to say to you is that the crown can decide today that it wants to run a road straight through here.
yeah, eminent
Wow.
domain, eminent domain. Yes, they can.
So would they pay you for your house?
Yeah,
Well,
they're supposed to, they can give you a fair market
Yeah.
value.
So by their standard.
By their standards, yes. Yes.
Yes,
When you
yeah.
go to you get your, what you call it, you get an estimate of.
No, worry about that. No.
yeah, you never. want-
You do not
everything
own
is
land.
fine.
Only thing you own is this.
Yes.
You own interests.
Yes, you own the interest.
You own the interest in that land.
Yes,
You do not own that outright. You can't say, I build my house here and I'm not moving, no one could move me from here. No,
Escrow
you
land.
only have an interest in land.
Yes.
That's all that piece of paper is telling you.
So
If you paid for it and you don't owe the bank, then you own it. Be simple, absolutely. If you have a mortgage, you only have this.
Not really,
No, the bank does, until you finish paying off that mortgage. And that's why they have the right to demand it after you have missed three consecutive payments. And that will come under the law of conveyancing, a different law.
It's a lot. These things are important to know.
yes, it is. Yes, it is.
So once the assets are transferred to the trustee, then of course, then the trustee becomes the legal owner of those assets. So the
But-
profit, go ahead.
But, said you say it wouldn't be good to non-lock it, but I could put a provision in it for it not to be sold.
Yes,
So I could put a provision.
yeah,
in
or you
it.
could put a provision in to sell it as soon as you die. Anyone.
No, but that's the whole idea. I don't want it to be sold after I die. I want it to be there.
Then
so-
my question to be to you, if this was being drafted is, then not only paying the mortgage, but you have to maintain that.
Yes. So after the mortgage, that's why I say, I can put the provision in, because I don't want to depend on the children them to keep the, do the.
Upkeep,
and the
right,
maintenance
okay,
and
the
all that.
maintenance and
So
everything,
I want
yeah.
All that, the provisions
done.
that they will be.
That's
doing, so
fine,
they
yeah.
never want to disrepair or anything like that.
Okay, yeah, that's fine.
So I can put that in the.
Trust me, they'll try to find a way so they can sell that.
Which would be their foolishness.
Yeah, but I mean, you'd be long gone, you wouldn't
Yeah,
know,
yeah.
yeah. So the property which is under the administration of the trustee is known as the corpus of the trust. And the trust property could also refer to be as the subject matter, and that could be bonds, stocks, cash, paintings, anything of personal property. All of that could be in a trust.
And so in the trust, so if that, all of that is, say, paintings for example.
Mhm.
So if it's in the trust will also be responsible for securing it, storage.
The
and
trustee,
all that,
yes, the
and
trustee.
all that. Okay,
Mhm.
excellent.
And having it valued and
Yeah.
appraised and all of
Yes.
that, making sure it's in good condition and whatever needs. But don't forget now, the beneficiaries, the grandchildren or great grandchildren, if they know the painting was valued at, say, 2 million, or even let's say 20,000 at that time. And they know that over the last 20 to 25 years, that painter has become big now, important now. And so they know that based upon the value, it should be 50 times more than what it was.
Mhm.
They come in the suit.
And they come to sue,
And-
Yeah,
and-
because they're gonna look at the,
but they want more money.
because they're gonna look at the appreciation of it and see, what did you do with the valuation of the property?
I mean, with the
If they
painting.
will value
With the
it.
painting,
But the
yeah.
painting, but you're not selling it, you only have it in storage and holding it.
Yeah, but see, you could have it in storage and holding it, you have to brace it.
Oh,
So let's just say you have it in holding, right? And you may have used it as collateral.
so let's say,
Oh.
When,
for the
It's-
investment.
You never know.
Okay.
You see, there's different things.
Yes.
The trustee have to make a decision how to make money.
Trust still has to consult with the beneficiary.
No,
If
no,
it
no.
choose to-
so
No,
who
they
used
don't.
it as
No,
collateral?
no.
The
No.
trustee use the earnings as collateral or the beneficiaries on the
No.
earnings as collateral?
No,
Oh,
no, the trustees.
oh. So that's why the beneficiaries can sue now.
Mhm.
If
Yeah.
they would
Depends on
say,
the decision that they make. It was not a good
Exactly.
decision at that time.
Yeah.
This was.
Unless they say the bank repossessed it.
Exactly.
So the
Could
bank
be
can
different
come to
things.
the trustee and take.
Yeah, if you didn't pay the loan or whatever it is. Or the loan or the value of the property depreciated, but you had no standing loan of this amount, the beneficiary could say, at that point in time, didn't you foresee that this would have happened? Why didn't you see this?
So if you have art, you would say if you are a trustee for that particular company that holds, that trust is just for art, you would get an appraisal. like
Yes, you have
every
to.
year,
Yes, you have to.
Every year.
Depends on the painting itself.
Let's say it was like from 1920.
I don't think you need it every year, because it's not gonna move that
Every
fast.
5 years.
But if you have someone, let's say you got a ping by Nathaniel and he's up and coming. You see what I mean? So maybe you want to get an appraisal every year, because an appraisal is money. More costs.
Altogether.
That thing for costs.
Yeah.
Okay.
So you have to, it's a balancing act. So there could be more than one trustee of a trust. So you know, if you have like a trust company, it's just one. But within your organization, you have different trust persons carrying out that work.
But then it's pointless. There may be more money to check, but then you're still covering yourself. If those beneficiaries come and be like, hey.
But you're covering yourself in two ways. You're spending more money for it. But when you say you're doing a CYA, when you do that, yes, you're doing a CYA on that side. But on the opposite side, trustee say you're spending too much money because it wasn't necessary. So you gotta buy, that's what I'm saying, it's a balancing thing. You know, you can't come keep telling me, they tell me the computer wasn't working good and they say something was happening out there, so I had the fella come look at it. Then next one, you hear something, and the fella, no, you're spending up my money. No, don't work like that. No,
Yeah, so
Right.
you must be gotta go online and Google, let's say, the per se artwork done by, let's say.
no, you get professionals. Now, don't
I mean,
forget
if you're
that,
trying to save cost, everything on Google now. What must be
no,
the
no,
hassle?
no, not when you're dealing with other people's property, no. But yeah, you gotta be mindful that these people can sue you, and they will sue you. They will.
Hmm.
So for next class, I will give you all, Alicia says she's gonna be in. So I would, have them copy a trust deed. And your homework is to print the trustee act and all of its amendments. Go to the Bahamas Financial Services Board website. And if you go down the list, you'll see trustee act, and then you'll see the amendments. Which is
That's the what, Bahamas?
Bahamas Financial Services Board. So next week we'll begin with creation of a trust. So Alicia, we hope to see you next week in class.
I definitely need to be there because cable,
Internet. Yeah.
yeah, cable is not the best.
Okay, Nathaniel is scribbling,
Okay.
so you can tell her now what you want to do. To meet her with her book, or you can't say. She's on.
Oh, she didn't go on?
No, she's on.
Oh, you could send me a location?
How far down these streets are? I don't want to put you out your way. So how far are you going?
I'm going to my farm in the Bamboo Town area, you know where Rhodes Auto is?
Rules, yeah. I'm not so far from Rhodes.
What about Pocky gas station?
The Parkins is further down.
Oh,
Which area you live?
I live close to the Pockets, but I can come to Rhodes.
Nah, man, no problem, man. I drive and I walk. So you could send me the location and I'll bring it because I'm right there on New Hope Drive.
Oh, right there, right by me. Okay.
Yeah, it's you behind Parkies, you probably on
I'm not behind Pockets. I'm in South Beach, but more like on the police station side. Well, you probably call it Pinewood, but I live South Beach side of the police station.
Well, no problem. Just send me the location and I'll bring it. But I'm stuck with the outdoor sportsman to get me a pants, then I'm coming.
Wherever you go, I'll be here. Thank you so much.
okay.
Alrighty. Okay,
All right,
thank
so
you.
See you next week, yes.
All right, thank you.
All right,
Okay, bye-bye.
bye-bye.
Right.
Okay.
Class
you
was
very
great.
Yes, very informative.
Yeah, I'm enjoying this.
I'm finding too.